The 11th Circuit Court of Appeals held its much anticipated hearing in the Department of Justice's expedited appeal of Judge Eileen Cannon's order finding equitable jurisdiction in the case involving Trump's theft of thousands of government records. It did not go well for Trump, would be putting it lightly. E. Jean Carroll files a new federal complaint under New York's adult survivor statute against Donald Trump for sexual assault. She also adds a new defamation count against Trump based on new statements he made in October of this year. The special counsel investigating Donald Trump's criminal conduct, Jack Smith, is already a very busy man. This week, we learned that the DOJ has been reaching out to former Vice President Mike Pence for questioning about Trump's crimes, and Pence is considering speaking with the Department of Justice. Not that he really has a choice in this matter, as Michael Popok and I will explain. The Supreme Court rules against Donald Trump in his emergency application to block turning over his tax returns to the House of Representatives, and Trump lashes out at this unanimous decision by the Supreme Court rejecting Trump's emergency relief by going on a deranged rant against the Supreme Court on his social media platform. And remember, 3 of those radical right-wing justices Trump appointed. And the right-wing Fifth Circuit Court of Appeals gave a bit of a surprising smackdown to a Trump MAGA judge who demanded that top-level Biden officials appear for deposition in a completely frivolous lawsuit brought by various Republican-led states against the Biden administration, alleging that the Biden administration was involved in social media moderation of anti-vax content. You can't make this stuff up, Popok. That's why you have Legal AF, the most consequential legal news of the week. Happy Thanksgiving, Michael Popok. Happy Thanksgiving to all the legal AFers out there. Hope you all are having some time with your families and relaxing a little bit while watching Legal AF. Popok, how are you?
I'm doing great. I can say this about that rundown that you just did. I don't think in the history of clients, a defendant has had a worse week in multiple venues across the country than Donald Trump, which is great because Donald Trump always likes to be the greatest, the best, the most. This is the greatest, the best, the most worst week that a client could ever have across 5 different courtrooms, all of which we're going to talk about today in 1 week. If I had a client like this, I would have to sit him down and with a pot of bourbon and have a long, deep conversation with him about how do we resolve these matters. Of course, Donald Trump's not going to do that. And we'll talk about when he hires which lawyer for which matter. It's going to be crazy depending upon which lawyer he uses. And we'll talk about the lawyers assigned to each of these 5 cases throughout today's podcast.
And I didn't even mention in the introduction the New York State civil case brought by New York Attorney General Letitia James, who is seeking at least $250 million in damages. There was a hearing earlier in the week where the presiding judge over that case, Judge Arthur Engoron, set trial date for October 23rd of 2023. And a lot of people, and I want to get your take on this, Popok, because there were so many comments like, that's still 11 months out. And I wanted to tell everybody, look, in New York court, that's like the fastest trial date I've ever seen ever. Trump is not getting any benefits there. And Popok, you practice in New York. Yeah. How quick of a trial date for a case that was filed late September? Have you even heard of a case going to trial in October of 2023?
You can barely get, and this is again not a criminal case. So criminal cases sometimes go a little bit faster because of right to trial. However, you can barely get an injunction hearing on an emergency application in less than a year. Trials in New York on the regular docket, 3, 5, 10 years away from an actual trial date. I'm in cases now, we don't even have a trial date set. And these cases were set 3 years ago. There's not even a trial date looming. So justice and the wheels of justice move at different paces in different jurisdictions, in different systems. Federal moves usually quicker. State moves slower. Civil moves slower. criminal moves faster. So you've got all these wheels of justice turning simultaneously, being led by prosecutors and civil lawyers like Robbie Kaplan, we're going to talk about, and E. Jean Carroll, and all of that. So you got, this isn't like a mass orchestrated thing. There's no conference call during the week for all of the prosecutors prosecuting Trump, state and federal, Robbie Kaplan doing the E. Jean Carroll. I mean, that would be like the conference call of my dreams, that would happen every week to talk about what can we do today to coordinate each other's cases and whipsaw Donald Trump. That doesn't happen. And that just shows you, though, that these wheels are independently moving, and it's based on docket, the length of time things take in that courthouse, and motion practice that Donald Trump files, usually without any credibility or merit, that does slow down the process. And we'll talk about that as well.
Judge Arthur Engoron pointed that out at the hearing earlier this week, this motion practice without merit. Alina Habba was representing Trump in that proceeding, which almost seems that he sends her there at this point as a complete troll to Judge Arthur Engoron, because she's just absolutely the worst, and she files like the most frivolous, made-up documents. And Arthur Engoron was like, what are you even filing? Like, what is this? Like,
I already denied these. He said, I already denied these very motions, just because you can't keep filing the same thing, Ms. Habba. Look, this goes back to what you and I described a few podcasts ago as the crazy, the crazy meritless axis or graph. The crazier and more meritless the motion or case, the more likely you're going to see Alina Habba. The more, credible is giving him a lot more credit than he should, but the more credible the argument, or at least it passes basic straight face test, the more likely you're going to see Jim Trusty, Corcoran, Susan Necklace, who's his defense lawyer in the criminal case in the Trump organization, and Chris Kites.
Chris Kites, yeah.
Kites. So that, if you see those guys, you can at least sit through the argument, although we'll talk about how Trusty was just flame broiled during the 11th Circuit earlier this week. But if it's really nuts out there, cuckoo, mad as a hatter, that's Alina Habba.
Yeah, the assistant New York attorney general who was arguing the case before Arthur Engoron after Alina Habba went up there, and she was like, this is unfair. This is unconstitutional. This is an abuse. The New York attorney general assistant was like, okay, literally, Judge, all she does is say those words, and she doesn't actually make an argument with evidence. Can we all appreciate that for 1 second? And then the judge was like, yeah, I'm ordering you to trial in October. And Popok, you mentioned Jim Trusty. I want to talk about Jim Trusty. Look, he had a not so easy task in representing Donald Trump before the 11th Circuit. He did a not so good job doing it, but I have no sympathy for him because this whole entire charade should never have taken place in the first place. It is completely unprecedented for a federal judge like Judge Eileen Cannon, a Southern District of Florida federal judge who was appointed by Donald Trump, to assert equitable jurisdiction, to enjoin the Department of Justice from engaging in a criminal investigation of an individual where there has been no finding that the Department of Justice engaged in unlawful conduct, yet alone the Department of Justice engaging in a callous disregard for the rights of somebody being investigated.
Or to put it in Chief Judge Breyer, one of the three on the panel we're going to talk about next, to put it in his words, the record is already complete and settled law now. The execution of the search warrant, in Judge Pryor's words, who chaired that panel, it was a lawful execution of a search warrant. And he posed that question to Trusty. He said right up front, that's why you knew this was not going to go well from the minute the first question came out of the box, both to the Department of Justice we're going to talk about, which was a softball. I've never seen such a softball thrown by a panel to an advocate in their favor, which was Chief Judge Pryor saying to the advocate for the Department of Justice, Basically, how would you like us to write the order in your favor? Should we write that the Judge Cannon's decision was vacated? You said reversed, but shouldn't it really be vacated because we're talking about jurisdiction? Oh my God, if I was on the other side of that, that's the first question to my opponent. You're toast. The question to trustee was no better, which was from Judge Pryor. Name us one case, give us one case where a federal judge exercised equitable jurisdiction where a search warrant was lawfully executed. Go ahead, we're waiting. And of course, he tap danced and said, maybe this one, or there's a case involving Rudy Giuliani that we're going to get to, which is what you're talking about.
Yeah, that was later, though, Popok.
Later in the, it's a 40-minute
oral argument, he admitted that it wasn't, that there was no case. And so, and then later on, like the next day, trustee then sends a letter to the 11th Circuit Court of Appeals and cites the Rudy Giuliani search warrant case, which was not a case involving equitable jurisdiction. And then the day after, on Thanksgiving, November 24th, for everybody wondering if Jack Smith was going to be caught up to speed, Jack Smith writes a letter to the 11th Circuit on the 24th, calling out trustee for being a liar and say, look, trustee just lied to you and said the Rudy Giuliani case involved a federal court's assertion of equitable jurisdiction. It wasn't. It was a case where we, the Department of Justice, executed a valid search warrant. We requested a special master simply because it was a very unique circumstance involving a lawyer and a law firm where there could be potentially other client documents at issue. And so we just thought, in the abundance of caution, the taint team wouldn't be the right use here. Let's just use a special master to be extra careful. That was not a federal judge enjoining or stopping the Department of Justice. But Popok, give me some other highlights you thought from this 11th Circuit oral argument. Well,
let's start with Jack Smith, who I, first of all, I'm going to come up with something new for him. I love the fact that he's Jack Smith. He's not John Smith. When he signs his pleadings, or people sign pleadings in his name, which is what happened here, Gonzalez, who's the U.S. attorney for the Southern District of Florida, signed it in the name of Jack Smith when they did this Thanksgiving filing. I love it. It's like James Bond, Jack Reacher, Jack Smith. And if it's James Bond, I'm telling you, Trump, after watching his lawyers get roasted, is now shaken and stirred, because Jack Smith is out for blood here. And he is, as you said, really up to speed in the case. What I liked about it was a couple of things. First of all, Trump got a terrible draw on purpose. This was not a random selection of a 3-judge panel at all. This was Chief Judge Pryor selecting 2 other people. And the 2 other justices that he selected, although Trump appointees, Judge Brasher and Judge Grant, were terrible picks for Trump and great for justice, because they were on the panel in September that ruled in favor of the Department of Justice and against Donald Trump on almost the same issues about whether Judge Cannon, had equitable jurisdiction to set up a special master process for 100 classified documents. They went out of their way in that multi-page opinion to not only say she did not have equitable jurisdiction at all, therefore stop, don't do anything else. They said, but because the Department of Justice asked a very narrow question of us on appeal, we have narrow jurisdiction ourselves. So we're going to say she didn't have equitable jurisdiction, but they basically, as we anticipated, Ben, in our podcasting, invited a bigger appeal about the entire assertion of equitable jurisdiction by Judge Cannon. Now, before I get to what you asked me, which is a couple of the high points led by both Judge Grant, Judge Brasher, and Chief Judge Pryor, each one of them were terribly skeptical of everything Donald Trump's lawyers was saying, and even cut him off at numerous places to correct the record and to note that there was nothing in the record to support most of his arguments.
What about when they cut him off, Popok, right away and said, when he said this raid, and they go, wasn't it just a valid execution of a search?
That was Judge Grant.
I'm sorry, Your Honor.
I agree with the court's premise that there's not case law. I would start with the broader premise, which is there's also not a situation in the history of this country where a sitting president authorized a raid of a presidential candidate's home. So we have some initial context.
Do you think that raid is the right term for execution of a warrant?
Or execution of a warrant. That's fine, Your Honor. I apologize for using a more loaded term.
Yeah, that was Judge Grant, Judge Britt Grant, who's a Trump appointee, when he said, because he can't help himself. He's got his talking points. They all do. They've got to attack Joe Biden and call it a political process that led to the quote unquote raid. That's on a little kitchen, index card or recipe card that they bring. They have to get it in. Otherwise, it's like a drinking game for Trump. If they don't get those words in, they get in trouble when they get home. So they got to get it in. But Grant cut him off and said, stop, basically stop. It wasn't a raid. It was the lawful execution of a search warrant. Isn't that what you meant, sir? And he said, yes, but then he couldn't help himself when he was responding to a question by Judge Breyer 10 or 15 minutes later. He tried it again, or Judge Brasher, and they both said, I thought we've already established that it's not a raid, because they had already read all the briefs and we knew where they were going. Just to clear up some misconceptions. Oral argument, most judges, having read the briefs, although they haven't really caucused officially yet, they sort of made up their mind about where they're going. They use oral argument to sort of sort out some of the questions they may have, push back on things that weren't in the brief or weren't properly developed in the brief. But they're fully prepared for this hearing, and they knew that they were going to start from the preposition or the presumption that this was a lawfully exercised search warrant. And so you have Judge Grant saying, isn't every argument that you're making, sir, an argument that any target of any search warrant before they're indicted would make? And it's no different just because your guy's the president or ex-president, right? And of course, he had to concede that. So she walked him into that trap. And that led to the trap that Judge Pryor laid, which is, name me one case where a properly exercised search warrant leads to the exercise of equitable jurisdiction to interfere with the executive function of the Department of Justice to investigate and prosecute a crime. I'm waiting. Give me one case. Now, Trump, I think this strategy is too smart by half, realizing, especially after they pulled that panel, that they were probably going to lose potentially Judge Cannon. They filed the night before the hearing. You talked about it in one of your hot takes. They filed the night before the hearing a motion for Judge Cannon to basically stay in the case, like an invitation to stay in the case. Because if her special master process goes out the window and therefore her equitable jurisdiction, finally, Eileen Cannon is out of this case. So they file a motion to keep her in, to kind of pull her back. And the motion is a motion to unseal the entire FBI affidavit that supported the search warrant, naming all of the confidential informants, naming the FBI agent, naming the people that ratted out Trump, stuff that you certainly are not going to give a criminal defendant, not even a criminal defendant, a pre-indictment target of a search warrant. Never happens. But and just so everybody knows, and we want to be fair, the redacted version of that affidavit was already released by the person that was appropriately exercising jurisdiction here, the magistrate judge. He already produced as much of that as possibly could be set out without compromising the.
Popok, can I pause you there for 1 second? Because
Sure.
Smart, in retrospect, was the magistrate Judge Reinhardt. We talk about playing chess and thinking many moves ahead. This guy back in August looked like 4 months ahead to what was going to happen, because a lot of people were even skeptical of him there unredacting certain portions of the affidavit supporting the search warrant, because that's very rare. And he held that hearing. He did the full analysis and then said, you know what, government, some of this, because of the public interest unique to this case, should be public, but I want to keep the names confidential. And he got some criticism because it's so rare to even do that. But in retrospect now, he kind of checkmated, right? It's a brilliant move.
I think you're right.
Do that.
You're right on it. And he took away the entire argument about the need for that. The other thing that was very interesting for me out of the 40 minutes was, and this is, we'll get into a lesson about appellate records and what can be argued on appeal and what can't be as it comes up from the trial level. Because some people might get the impression, based on Jim Trustee's presentation, that you can argue basically anything, throw it against the wall and hope that the panel will bite at it. If it's not in the trial record from below, preserved literally in a big R, capital R record that the parties have to literally prepare with the clerk of the court, numbering the pages R1 through R whatever of documents, briefs, exhibits, evidence, whatever was below. You can't come into court on the day of your appeal or even in your appellate brief that you filed and attach a new piece of evidence, a new testimony, a new deposition transcript, a new argument that wasn't raised below, or at least raised the trial level. You certainly can't do it on your feet when you're arguing your oral argument. And so when Trustee kept saying, well, it's no secret that we'll be arguing that it's a general warrant, which is under constitutional law, we don't like having criminal judges issuing just general warrants to go look in this person's house and see what you find. That's sort of a general warrant. And they're arguing somehow this was a general warrant. But it's no secret that we're arguing it's a general warrant. It's no secret that we'll be arguing eventually, sometime in the future, based on we don't know what yet, that this was an improperly executed search warrant. And Chief Judge Pryor stopped him and said, all right, stop. None of what you're talking about right now is in the record, sir, is it? He said, no. He said, all right, so it's a secret to us as the appellate panel. It is a secret because it's not in the record. And basically, if it's not in the record, stop arguing it here because we're not going to be able to rely on it in making our ruling. And what Judge Pryor is most concerned about, and I think he's going to write the decision, what Judge Pryor is most concerned about is precedent, things you and I have talked about. This is why the Department of Justice had to challenge Judge Cannon, because you couldn't leave this on the books for some future Jim Trustee to pull out and try to argue, oh, the case of Trump versus, U.S. and the Judge Cannon, you got to take it off the books, terrible law. And he said Judge Pryor said there's a separation of powers problem here that I am very concerned about. And it's not just about Judge Cannon. They were very upfront, that panel, Ben, and they said it is about the future Judge Cannons, the instructions that we're giving to the future federal judges about their exercise of equitable jurisdiction in the face of the Department of Justice trying to do an investigation criminally. They are concerned about it. They're concerned about the precedent-setting nature of it. And that's why they kept interrupting Trustee with, we have a bigger case here. We're worried about the next Eileen Cannon doing something. And that and the separation of powers is what's, I think, going to drive the decision. That there's no precedent in favor of, thank God. I mean, could you think what the world would be like if every target pre-indictment, they're not even a criminal, he's not yet, Trump, a criminal defendant. He will be, but he's not yet. If they could just run into court and say, I don't like the search warrant, they were mean. They threw things on the floor. They took that memento that I wanted from North Korea or whatever it was, and stop the investigation while we sort it out with a special master. This would turn criminal jurisprudence, federal or state, on its head.
And it would turn the executive branch inside out. The whole notion of equitable jurisdiction is that in the rarest of circumstances that the government is engaging in such a abuse of someone's rights, and it's so obvious, like, what are you doing, that a judge has to step in and go, all right, let's chill here for a second. And because otherwise the judge is now becoming like a counter executive branch. You are stopping the executive branch's functions. You are no longer functioning as the judiciary where you're supposed to call balls and strikes. You are now overruling what executive branch decisions can be. And that's really, again, to your point, Popok, this broader issue of what's at stake here and why Judge Eileen Cannon's decision was so completely wrong. Popok, final words there, because I want to move on to
I do too. So the way I use this on one of my takes on it. Interference between the branches is really important, and just as we wouldn't want the judiciary, the judges, to interfere with the executive function of the Department of Justice in doing its job as a co-equal branch of government, which is to investigate and prosecute possible crimes. It would be like if the Department of Justice walked into Eileen Cannon's office on a Tuesday and said, yeah, you're not going to be issuing injunctions today. What do you mean? We decided, the Department of Justice decided, no more injunctions. With Tuesdays, no injunction day in Eileen Cannon's courtroom in any case. Okay, got it? That would be interference by the Department of Justice in the exercise of the judicial branch. And we can play this game all along with the executive branch. So this thing is serious. The same thing that Trump wallpapers over at his lawyers, the separation of powers, is a serious thing, and it's the foundation of our constitutional republic.
Let's travel north from Georgia, where these oral arguments were taking place before the 11th Circuit panel, and let's head to New York, where E. Jean Carroll filed a new federal complaint under New York's Adult Survivors Act against Donald Trump, this time alleging sexual assault. She also added a new defamation count in this federal lawsuit filed in the Southern District of New York. Now, you'll recall that E. Jean Carroll previously filed a defamation lawsuit against Donald Trump back in November of 2019 after Donald Trump, while he was still the president, in a number of press statements and press conferences, made defamatory statements about E. Jean Carroll after she came out with the fact that Donald Trump had sexually assaulted her in the mid-1990s at a Bergdorf Goodman, which is something that she stated happened in a book that she wrote, and she hadn't talked about it before as she had felt intimidated. And during the Me Too movement, and as other people began speaking out against Trump, she felt it was important to tell her story. But her statute of limitations for the underlying sexual assault in New York had expired, so she couldn't sue for sexual assault, but she did sue for defamation because Donald Trump made a number of derogatory and defamatory statements about her, and saying that he would never touch someone who looked like that, or statements that are disgusting to that effect. Donald Trump then repeated those statements again when he was not the president. He said it on his social media platform in October, which is an important distinction because he was cloaked with potential immunities as the president that worked its way all the way up to the Court of Appeals, where the Second Circuit had found that the district court judge partially erred in made an error in that Donald Trump was not a federal employee under the Westfall Act. The Second Circuit said he was a federal employee. But then the question of whether Trump's statements about E. Jean Carroll while he was the president was in the course and scope of his employment. They sent that question, and they certified that question to the highest court in D.C., in Washington, D.C., before their Court of Appeals there, in the highest court within the district. So that's still playing out, and it's possible there that E. Jean Carroll's underlying defamation case gets thrown out. We don't know, but her new defamation case when he was not president definitely doesn't have immunities, so she can pursue that. And she can now file a claim for the underlying sexual assault under New York's Adult Survivors Act, which was signed into law and recently took effect. In fact, it took effect for the first time on Thursday, which has a 1-year look-back window for people who were victims of sexual assault, certain delineated sexual assault crimes. So in E. Jean Carroll's lawsuit, she cites the criminal conduct that was at issue with the sexual assault. And for people whose statute of limitations expired, there's this 1-year look back period where she can sue up until next year's, 1 year from that Thursday, unless it's extended again, but it's 1 year. So she filed the underlying case for sexual assault. Popok, what do you make of this new lawsuit?
Well, a couple of things. First of all, shout out to Robbie Kaplan, the lawyer who represents E. Jean Carroll. We've had her on the show, Karen Friedman-Agnifilo and I, in the midweek, right when the Dobbs abortion decision was leaked. We were fortunate enough to have Robbie Kaplan on the show. We didn't know that was going to happen. We had her on the show for another reason, including talking about E. Jean Carroll and some cases down in Florida that she was bringing against Trump. And we'll try to get her back to talk about this one. I read, I'm sure you did too, Ben, I read the complaint that was filed the day of the opening window of the Adult Survivors Act. We read these things so everybody in legal AF world doesn't have to. They can, but they don't have to. And I was really struck by a few things. First, master a master class and master craft by Robbie, because she not only brought the civil rape case, let's just think about that, a civil rape case against a president of the United States. He's now former, but it's just breathtaking in how terrible a series of events this has been with Trump having been president, former president. The second thing is how smart Robbie was to add, as you and I predicted. You were one of the first ones that said, keep tweeting, keep social truthing. You're just adding new claims that are outside of immunity for defamation against E. Jean Carroll. That's exactly what Robbie did. She added a claim because she wants to tie these cases together as related cases. She says in the new pleading, the new lawsuit, just to give a little bit of a procedure class here, the first lawsuit is already pending on defamation. It is scheduled for trial in April. There is a January oral argument at the DC, as we talked about, a Court of Appeals to determine whether Trump was within the course and scope of his employment as president of the United States when he made these statements denying E. Jean Carroll's charge of rape and defaming her. Yes or no? And if he's in the scope, it's going to go back to the Second Circuit, and ultimately those claims will just continue. But in the meantime, Lewis Kaplan, the judge, who's not related to Robbie, as all the papers like to report, has the trial setting. We've known about this new case being filed because Robbie Kaplan's firm has been very public about literally within a minute after the opening window for the new filing of these cases, which is basically 60 days after Governor Hochul signed the act, giving people time to draft up their complaints. Then you could first file. And it's interesting, just as a side note, there were two major cases that were filed almost at the same time, being the first cases in New York. One of them is E. Jean Carroll. The other is a class action or a series of cases that filed against major banks based in New York, like J.P. Morgan Chase, for the Jeffrey Epstein scandal, that they helped perpetuate his sex scandal and his sex schemes by letting money flow in and out of their bank accounts that he then used to rape these young girls. So it's interesting bookends for the two cases that were filed. So you have a defamation, a brand new case that's filed, though. Same parties, same lawyers. Now the question is, are those two cases going to be joined together as related cases and consolidated? Robbie's arguing that they should be. She's put in the hooks in her new case in order for that to happen. She said it is related to the other case. It is new defamation based on on his Truth Social about the same events, and there should be a jurisdiction for the judge to put them together. So they're arguing to put them together. Of course, the Trump organization, Donald Trump's lawyers, including Alina Habba, again, makes the argument like, I don't even know, Judge, if I'm going to be retained for this case, and we need more time. And the judge cut her off at another hearing last week and said, with all due respect, you knew about this new case coming because Ms. Kaplan's law firm has talked about it for quite some time. You knew it was going to come on today. You should have got your ducks in a row in terms of representation going into today. And I'm not stopping the trial. And I'm going to table for today. I'm going to take under advisement the question of whether I'm going to join these two cases together. Again, always subject to what the Court of Appeals does at the DC level on the other case. But even if the DC Court of Appeals rules somehow in Trump's favor and finds he was inside the scope of his employment when he defamed E. Jean Carroll, and therefore gets the benefit of what's called Westfall immunity because he's a federal employee and is inside the scope and therefore he can't be sued, doesn't matter because he has a new defamation claim against him now based on the same facts in the Bergdorf Goodman dressing room where this terrible crime took place. And he's got actions, the civil rape, the rape of E. Jean Carroll that happened before he was president. So this case is going to trial. And this case is going to trial with Robbie Kaplan versus Trump, with her client, E. Jean Carroll, with all of her evidence, including apparently physical evidence that she has from the attack. And a jury's going to have to make this decision. This case is not getting dismissed in advance. There's going to be a jury picked in this case sometime in 2023 spring, and they're going to have to sit and adjudicate whether Donald Trump raped her and then defamed her in 1995 or 1996.
The only caveat that I would say is it's possible the trial may be delayed, and you and I may disagree on this, that with the new claims that are asserted, I think that Judge Kaplan, not related to lawyer Kaplan, but the Judge Kaplan presiding over it, he's been no nonsense with Trump. I do think, though, to protect his record on appeal with the new claims being asserted, he may set that trial for around October of 2023.
Oh, so you're still in 2023, though?
Early, more likely early 2023, late 2023 rather, would be me being optimistic and wanting that to happen. I think that trial with the new assault claim probably is February to March of 2024.
I don't disagree that he might add on 6 more months to give them more time, but what are the factual differences between him having to prove that it was not true that he did it, basically, or that she's lying about what happened in that Bergdorf Goodman dressing room when he raped her in that dressing room, according to E. Jean Carroll? What's the difference between that, the discovery and the witnesses that would go into that issue of defamation and the physical rape issue? I don't see the new discovery.
The true answer is there is nothing. But could someone who's being sued make an argument to the court, and a court feeling like there could be potential issues on appeal if you don't give an appropriate time frame here, and say, look, the new claims of a sexual assault are actually, far more serious claims than a defamation claim. There are all these New York laws being cited. We're going to have to consult with criminal counsel now. It's going to impact the like, you can make up a bunch of stuff, and I'm not trying at all to make those arguments, but I think that those arguments will give you a little bit of rope, but not too much rope is my read there. Because I'm with you, Popok. There truly is nothing, but Trump will make those arguments, and the judge will be cognizant not to make sure that to avoid a situation where a jury reaches a verdict against Trump, that could be appealed for violating any due process.
Let's make that a teachable moment point. Trial judges look to their appellate courts above them, and will make decisions not only based on written precedent, of course, written precedent, binding precedent in that jurisdiction, but also how they feel based on the Second Circuit in this case, or any circuit, how they will see a trial judge's conduct and whether it's going to be a reversible error or not. Trial judges, like most human beings, don't like to make error. And trial judges don't like to make reversible error. It's terrible on their statistics. It looks terrible for them as jurists for that to happen. It happens. I mean, I don't think there's a judge alive that hasn't been reversed on some issue, some point by a higher authority, but they'd rather not. And so they are mindful of these things. They're mindful of the precedent of their jurisdiction. They're mindful, if it's federal, of Supreme Court precedent. But they're also mindful that I don't want to screw this up. So you're right. They might just throw them, you know what? I don't want an argument on appeal about not enough time was given for discovery and too short a period for trial. So what is the problem? Let's just go another 6 months. I mean, E. Jean Carroll, had 20 years to bring the case. So giving the defendant another 6 months really doesn't matter. It could land right in the middle of he's running for office, which is, that's his problem, that, the timing bites him in the backside because he's in trial during a campaign.
And if you don't follow the rules and you don't follow the law and you go rogue, the Court of Appeals can do a number of things to make your life and future career as a federal court judge very uncomfortable. Look at what the 11th, exactly. Look at what the 11th Circuit Court of Appeals did with Judge Cannon. And then later in the episode, look at what the 5th Circuit Court of Appeals is making the federal judge Terry Dowdy do, the Trump appointed judge. And and the Fifth Circuit is like actually making Terry Doughty go through all these hoops and justify why you did this and justify why you did that, and really called Judge Doughty out, this Trump MAGA judge. We'll talk about that later. But let's talk now about Jack Smith. Very busy. We talked earlier in the podcast about Jack Smith sending a letter on Thanksgiving calling out Trump's lawyers for lying to the 11th Circuit Court of Appeals. And we learned last week before the holidays had begun that the Department of Justice has reached out to former Vice President Pence to ask him questions about Trump's crimes and to interview him. This technically started a little bit before the appointment of the special counsel with Thomas Windom, who's also been leading the investigations into Trump's crimes. Windom now joins the special counsel's team. And you know, from what the reporting is, Pence has a different view about a Department of Justice subpoena or an attempt to question him. There hasn't been a subpoena yet, versus the January 6th committee. And Pence frames the issues, and I think it's BS, but he frames the issue against the January 6th committee as, well, this is a separation of powers issue here. So no, I will just write books about it, but I'm not going to talk about it because I am a Christian first, I am a conservative second, and I am a Republican third. So if there is an election denying candidate who wanted to kill me, as a Republican, I would support that individual. I would definitely think deep and hard about it, but I would support anyone who wanted to murder me because, third, I am a Republican. That's my.
I was going to say he was almost a hanging Christian Republican. He was almost hanging from a rope.
What do you do? Just be a normal human being. What are you doing? These people tried to kill you. Like, what the heck are you talking about? Anyway, Popok, break down what. And the Department of Justice being the executive branch, them having questions for Pence. He doesn't really have any of the same arguments that he can make for a separation of powers, even though I think he'd lose the separation of powers argument against Congress. But here's one thing I want to say, too. We've been saying about this on Legal AF is that the Department of Justice, through these grand jury proceedings that have been taking place, have been fighting hard against Trump's assertions of executive privilege, stopping Pence's former top-level staffers, Mark Short, the former chief of staff to Pence, Greg Jacobs, the former general counsel to Pence. And so Trump tried to block their testimony. They testified over the summer. When they were asked about their communications with Trump, they said, we can't answer it. Trump's asserting executive privilege. We'd like to answer it. Just get a court order. The Department of Justice did that. And then Judge Beryl Howell, the presiding federal judge over the grand juries in Washington, D.C., ordered Mark Short, the former chief of staff, and Greg Jacobs, the former general counsel to Pence, to testify. But here's what I've always been saying on Legal AF to everybody who's been saying, I wish that Merrick Garland did the indictment of Trump like years ago. And I always say to you, I agree. I wish that too. But just think, if they didn't build that foundation, like building a building, they wouldn't have even been got to this point where Pence is feeling like, I may have to testify because this judge has already made these rulings, because of the methodical and careful way that it's been built versus a haphazard scattershot approach, which, by the way, a haphazard scattershot approach may work. But I want someone to be diligent and careful and precise when you are going against someone who was a former president and a complete maniac like Donald Trump. Popok.
I'm going to put it even simpler. There is no doubt in my mind that for the last 2 years, since Jan 6th, coming up 2 years, that there has been a large group of Department of Justice personnel, prosecutors, line prosecutors, special prosecutors, and FBI agents that have done nothing but get up in the morning and brush their teeth and think about Donald Trump and think about Jan 6th and the insurrectionists and 900 other prosecutions until they put their head back on a pillow at all. That takes time. If it was a smaller, let me put it this way, if it was smaller insurrection, they would have gone faster. But when you have 900 people, more, they prosecuted 900 people. There were thousands of people who were swarming the Capitol. 900 are identified and prosecuted as criminal defendants. And then backing up to that to figure out from a timeline, how did that happen? Who lit the match? What were the conversations had? Thousands and thousands and thousands of interviews. But it had to be done. There is no shortcut to justice. We'd like it. I'd like microwave justice. I'd like TV justice. But we would all be kicking ourselves and kicking the Department of Justice if they didn't turn over every rock and they didn't do every interview. They didn't strip away every executive privilege and every attorney-client privilege and get every witness. It's extraordinary what they've been doing. They're getting lawyers to flip on clients being Trump, clients being Pence. Trump, they're blowing through sacrosanct attorney-client privilege and getting the Eastmans of the world to be in the firing line. And having federal judges declare Trump a criminal and lawyers a criminal. People have been disbarred who have been involved. I mean, there's a lot that's been accomplished. When the final scorecard for Merrick Garland is assembled, I think we're going to be proud of the work he did. I also think they took one for the team before Jack Smith was appointed. They knew that Jack Smith was coming on board, but they let the Department of Justice and the other prosecutor that you mentioned, and ultimately Merrick Garland, put out the feeler for Pence. They figured, you know what, he's got a lot on his plate on day one. Now that the midterms are over, we'll take it. We'll take that one. So they started the process, and now Jack Smith, of course, is picking up the pieces. I saw all the reporting. You're totally right in your approach. I don't understand why you get to write a memoir about how scared you were on Jan 6 and how you thought your boss lost his mind about it. And then, he's very it's very interesting because he's also candidate Pence. He hasn't announced yet, but he's getting awful close. And he's trying to find a way to thread the needle to keep as many Trump supporters as possible without alienating them. Whether he alienates Trump or not, I'm not sure it matters, but he doesn't want to alienate that red meat base because he wants to get it over to him. So now he's saying things along the lines of, when they asked him in interviews recently, they said, well, what did you think about the hang Mike Pence comment? And he said, I'm not sure it's a crime to get terrible legal advice, meaning Giuliani, Powell, Eastman, Boris Epstein, and all the other people in the Jenna Ellis, all those other terrible lawyers in that inner sanctum. So you can see how he's trying to spin this. But as you said, he was adamant about not testifying to Jan 6 because of separation of powers, but less adamant about whether he's going to voluntarily cooperate with the Department of Justice or make them go through their paces of going through a grand jury process through Judge Howell's courtroom to subpoena him, and then whether there's going to be an assertion of executive privilege. Apparently, the focus for the Department of Justice, based on reporting, is on the phone call specifically between Trump and Pence at 11:20 a.m., before the Jan 6 insurrection on Jan 6th about, hey, Mike, can you do us a favor here and don't certify the election while we work backdoor to try to get all these election integrity issues resolved, or whatever the effing phone call was. And that was the phone call that they wanted, which is interesting because that really would tie Trump's fingerprints to an obstruction of the free elections and the transfer of power. So among other things, they'll ask him. But there's going to be a negotiation process to see if they're going to let him come in and give voluntary testimony or through the grand jury process. And you and I will have to do it. The other interesting thing before we leave the topic, Ben, is who's representing Mike Pence. It's Emmett Flood, who used to represent Donald Trump back in the day, but is very well considered in legal circles and as a defense lawyer for politicians. Flip sides a long time ago, and even ratted out, it even criticized Trump as a former client, and is now a lawyer du jour for people like Mike Pence when they need a real lawyer, not Alina Habba, to defend them with the Department of Justice.
Absolutely. Definitely no Alina Habba. Alina Habba, though, makes me happy. Okay. Whenever Alina Habba is in a
that
case,
she exists makes me happy.
Or she's doing an argument somewhere, or her name is on the pleading. I smile. I go, okay, this is going to be fun. Trump's going to be sanctioned. And it's like, it's so easy for me to predict the outcome. It's usually very easy for me to predict the outcomes of Trump cases. But on an Alina Habba one, I know I'll be 100 for 100.
Can I ask you a question? I want to ask you a question. An honest question. Who do you think decides ultimately which lawyer is, besides the lawyers having their own interest in deciding whether they want to do that case or not, who do you think decides what's going to go to Alina Habba, what she's going to argue, what's going to go to Kais, what trustee's going to, this isn't just random selection. Yeah. It's not like they sit around. Who do you think is saying,
I know
give
what
it to Alina, give it to Kais?
I know Trump's personality. I know what happened. So he doesn't even, they all think they're going to be doing the argument and none of them really know. But Trump would never, he knows where Habba should argue. He knows that if she argued in front of the 11th Circuit or if she actually did the oral argument on a serious motion, that it would just be so embarrassing and humiliating. But he'll let her think that she may be doing it. And then at the last minute, he'll tell trustee, he'll be like, all right, I need you to do this tomorrow. You're gonna do this, right? And trustee, and they pretty much just know based on their experience who's gonna do what.
Yeah. And on the briefs. And they make the decision on the briefs because they have to be, they got to really be on the brief to argue. But I agree with you. I think he lets everybody think that they are, the top dog. And then at the end, he's smart enough to know that Alina Habba is not smart enough and that she's. And the other thing we haven't talked about today, although we've talked about it at length, is this third parallel track that goes along with the lawyers and the judges, which is Donald Trump's continued social media presence and the not only infuriating, demeaning, misogynistic, degrading, defamatory things that he says about everybody. FBI, DOJ, Merrick Garland, the judge that's presiding over his case, the prosecutor or the attorney general that's got the case. I mean, really disgusting things. And of course, the lawyers try to come in clean hands, while you never hear, for instance, you'll never hear in a courtroom, Alina Habba call Letitia James Peekaboo James, which is a racial dog whistle. I won't even go into what it's related to. That Trump calls the nickname, the terrible racist nickname that Trump gives to Letitia James. You'll hear Alina Habba say she's a political hack. You'll hear her say she is, there's no one that benefits more from this than the politically corrupt and compromised Letitia James. But they leave it to Trump to do the dirty work, which is to call her a racist name or to go after and attack. You'll see Alina Habba stupidly attack Jack Smith, although she'll never be in a courtroom at the same time with Jack Smith ever, based on our analysis here. But you'll have Trump and the others then follow suit, attack Jack Smith's wife. Talk about misogyny knowing no boundaries. What does it matter? I thought it didn't matter what wives did or husbands did. In Clarence Thomas, it doesn't matter that Ginny Thomas is an insurrectionist, that she was trying to create the fake, to promote the fake elector scheme and was emailing and texting and meeting with all sorts of people in order to promote that. But that's not Clarence. But here it matters that Jack Smith, who's completely apolitical, who is an independent and there's nothing they can tie him to in terms of his own political leanings, but they have to go for the wife because she's a documentarian that once did a documentary on Michelle Obama. Who cares? I thought it didn't matter what the spouse did. Only matters, but you'll never get, my point is you'll never get the lawyer to say this out loud, but almost parallel to them in the courtroom, Trump will be tweeting all, or whatever he's doing, all of this crazy, racist, misogynist things against his opponents.
Well, he's getting his just desserts, and we'll talk more about some of those just desserts because his tax returns were handed over to the House Ways and Means Committee. Trump's been trying to block that for many years. But first, I want to talk to you about Athletic Greens. Today's program is brought to you by Athletic Greens, the health and wellness company that makes comprehensive daily nutrition really simple. With so many stressors in life, it's difficult to maintain effective nutritional habits and give our bodies the nutrients it needs to thrive. Busy schedules, poor sleep, exercise, the environment, work stress, or simply not eating enough of the right foods can leave us deficient in key nutritional areas. AG1 by Athletic Greens, the category-leading superfood product, brings comprehensive and convenient daily nutrition to everybody. Keeping up with the research, knowing what to do, and taking a bunch of pills and capsules is hard on the stomach and hard to keep up with. To help each of us be our best, they simplify the path to better nutrition by giving you the one thing with all the best things. And that's what I love about Athletic Greens. Before AG1, I would just take a number of pills and gummies and have no clue what the heck I was doing. But with Athletic Greens, I put one scoop of this green powder that tastes really, really, really good into a cup. I put the water in, I shake it up, I drink it. It is fantastic. It tastes fantastic. It's cheaper than your cold brew habit, and it gives you all the vitamins, minerals, and whole food sourced ingredients that you need. 75 of them to be exact in one convenient daily serving. The special blend of high quality bioavailable ingredients in a scoop of AG1 works together to fill those nutritional gaps in your diet, to support your energy and focus, to aid with your gut health and digestion, and to support your healthy immune system. And it replaces those multiple products or pills with one healthy, delicious drink. And it's lifestyle friendly. So whether you eat keto, paleo, vegan, dairy-free, gluten-free, it's for you. It contains less than a gram of sugar, no GMOs, and no nasty chemicals, and it tastes great. Join the movement of athletes, lifeleets, and legal A efforts and get your Athletic Greens AG1 today. And to make it easy, Athletic Greens is going to give you an immune-supporting free 1-year supply of vitamin D and 5 free travel packs with your first purchase. But here's what you got to do. Visit athleticgreens.com/legalaf today. Again, simply visit athleticgreens.com/legalaf to take control of your health and give AG1 a try. I really, really like AG1. It tastes good, and I think you will enjoy it as well. And moving to our next sponsor, which I love too, and Popok, I know you love this, Aura Frames. They do these digital photos for your wall. And Popok, you said, hey, Ben, toss this one to me because I got 3 of these and they look good. Popok, tell us about your experience.
Yeah. So I love Aura Frames. They've been with us before, usually around the holiday times, if not beyond. I'll say it out loud. I'm proud. I've got 3 Aura Frames. I've got one. I do. I have one at my home.
I talk about it all the time.
I know. I have one at my home, one in my office, and I gave one to my mom. And the reason I like Aura Frames as a digital frame is because I remember the ones from 10 and 15 years ago, which were terrible technology. And Aura Frames is the exact opposite because it's really easy to do right from the comfort of your own mobile phone or laptop. You have your pictures, whatever they are, and then you can instantly, by pulling up the Aura app, you can instantly just check next to every photo, hundreds and hundreds of photos if you're on a trip the way I am today, and you could just check all those photos and send them. There'll be a list of the frames that you own underneath. If you have 1, 2, or 3 frames, I just click the ones I want, and then instantaneously, all of those photos, by the time I get home, are already rotating, maybe with music, through the Aura frame. And it's great because with my mom particularly, who I don't see as often, unfortunately, I can send her photos that I know she loves to see about what's going on in my life, and I can just shoot it rather than really just talk to her about it. I can shoot it to her frame without her even really knowing about it. And then when I get her on the phone the next time, I say, Mom, go look on the frame. I'll walk you through some of these great new pictures that I just loaded. It's really great. And it's also a nice way to literally connect with people and family and extended family that you don't see regularly by sharing with their life. Social media is one thing, but having a personalized frame on a table or a kitchen countertop or living room, really, really can't be beat.
Named the best digital picture frame by Wirecutter, The Strategist, and more. Aura's nothing like the digital frames from a decade ago. As Popok said, every Aura frame is thoughtfully designed to fit any decor style with a stunning HD display, unlimited storage, super easy setup, and no fees. Aura Frames makes easy, meaningful holiday gifts, especially for the hard-to-shop for folks in your life. Right now, listeners can take advantage of Aura's Cyber Monday sale and get up up to $50 off their best-selling Carver matte frames. Just go to auraframes.com/legalaf. And here's how you spell it. AURAFRAMES.com. AURAFRAMES.com/legalaf. That's auraframes.com/legalaf. This is Aura's lowest price ever, so get yours now before they sell out. And if you miss this sale, there will still be great deals through the end of the year. Terms and conditions apply. auraframes.com/legalaf. Popok. Donald Trump is turning over his tax returns.
I don't know what that was, but I liked it.
That's how I transition now. I just sing Donald Trump. That's how I do my transitions. Donald Trump has to turn over his tax returns to the House Ways and Means Committee. In fact, he doesn't really have to even do anything. The IRS gets to turn it over. So the House Ways and Means Committee will get it. And for everyone saying, oh, it's too late for them to have it, it really isn't. They're going to have it in time. They're going to be able to read it. Trust me, they'll be able to go through it before the Republican MAGA extremists will try to stop things like that from happening. So I'm not worried that it happened. I would have liked it to happen sooner, but I'm still happy that we'll get them and the right people will be able to read them, and it's not going to be blocked. So this is a big deal. You may recall that the Chief Justice John Roberts, who is the supervising judge for emergency applications from the D.C. Circuit Court of Appeals, granted a temporary stay blocking the House and Ways committees from getting these records after Donald Trump lost at every level in the D.C. federal court system, lost in the federal court, lost in the D.C. Circuit Court of Appeals. And everybody was like, John Roberts is the absolute worst. And look what he's doing. He's so corrupt. And I said, he is the worst and he's very corrupt, but not for this. I said, for this one, this is what he's going to do. He's going to grant a temporary stay. He's going to have briefing. He's going to refer it to the full court. And then the full court is going to deny on a unanimous basis Donald Trump's emergency application to try to block it. The House Ways and Means Committee has an absolute right to it. There is a mandatory audit function by the IRS of presidential tax returns. Donald Trump is the only president who didn't turn over his tax returns publicly while also whining about the IRS being corrupt and that that's the way he couldn't turn it over. During the Trump administration, he used his Treasury Department, which oversees the IRS, to block this from happening. Biden then followed the law and said, yeah, that's fine. This is what the law is. Presidents shouldn't be hiding their tax returns if you want to become the president of the United States. Trump intervened to try to block it, lost at every level, did this Hail Mary to the Supreme Court. Roberts only gave a 2 or 3 week block of the records being turned over. And then the Supreme Court unanimously ruled against Donald Trump, just like what we said was going to happen here on Legal AF. And as I said, a lot of reasons to criticize Roberts, a lot more reasons to criticize Clarence Thomas, a lot more reasons to criticize this entire Supreme Court. They've made the right rulings, though, with respect to Trump. Popok.
Yeah, and this is the new post-attack criticism on the Supreme Court that we talked about last year, in which we talked about the shadow docket, which was emergency applications for appeal being made to the Supreme Court from circuits that were headed and supervised by associate justices and justices that were on the right wing that would then make the decision on their own without full briefing, without oral argument, rather than refer it over to the full 9 for full briefing and argument. And so there was so much criticism, thank God, by media outlets, including Legal AF and MeidasTouch, that I think they've thought better about it. And now, within a week's time, we had Justice Kagan, Justice Amy Coney Barrett, and Justice Roberts all doing the exact same thing in the cases that were coming up from their circuits, which was to issue a temporary stay, emergency stay, because that usually signals that they're going to refer it over to the full panel of 9. They want full briefing. They'll set a briefing schedule from that. And then, better things will come out of that process, because you'll have full briefs, maybe an oral argument, although they haven't done oral argument on these emergency applications as of late, but you do get a ruling out of it, which is what we just got. Just to remind everybody to kind of put the jigsaw puzzle together, this is not the first time the Supreme Court has allowed Donald Trump's tax returns to go somewhere. Back in 2020, in 2021, Cy Vance, who was then not only Karen Friedman Agnifalo's boss, but was also the Manhattan District Attorney, he tried to get 7 or 8 years worth of tax returns as part of their investigation, an investigation that is now playing out, at least part of it, in a Manhattan courtroom against the Trump Organization for loan inflation, but started as, let's see your tax returns. Trump fought that, took 2 years, but Justice Roberts and the rest of the then Supreme Court, with no dissents, just like now, said those tax returns got to get turned over to Cy Vance, the Manhattan DA's office, which is why, Donald Trump, people might be saying why he's complaining so much about the Supreme Court always rules against me. They don't always rule against him, but they have ruled against him consistently on records turnover issues, tax return turnover issues to the appropriate authorities, whether it be the Jan 6 committee, the Manhattan DA's office, or in this case, over to the House Ways and Means Committee. House Ways and Means Committee was looking for a batch of 6 years of tax returns. There were and SCOTUS, after this started in 2019, just to show you how quickly things are moving. Like, let's say we're a year away from a case in New York, a New York Attorney General. This is 3 years that the House Ways and Means Committee has been seeking 6 years of tax returns, and they finally got them. I agree with you wholeheartedly that in the 6 or 7 weeks that's remaining before the 118th Congress comes in, there's time for the House Ways and Means Committee to review these documents from the IRS and make public whatever they'd like in a hearing. And they, of course, have the jurisdiction to do that under federal statutes. I'm not sure they have enough time, Ben, though. I want to hear your opinion on this, to pass legislation, which is what the House Ways and Means Committee ultimate goal was going to be, which is to look at the tax returns and then make decisions for future presidents about changes in reporting and law and get law passed. They don't have time to get law passed, Ben, right?
I agree with you, Popok, but I mean, the chances of them really getting the legislation passed
Right.
with the Republican members in the Senate, who would likely block it and filibuster it and stretch it out anyway, unfortunately, was not likely. But nonetheless, they have this legislative oversight function, and I think for purposes of what we want as the public to know that there is scrutiny, accountability, determination if there was any improper conduct, and the legislative cycles, over time, as we begin reflecting back, Democrats have reflected appropriately, but I think as Trump spirals ever more into these deranged levels that even for Trump, we haven't seen these depths quite yet, where you think, wow, can you even go lower than that? I think that as a country, this will put us in the right position, hopefully, to pass legislation in the coming years.
And to your point and to our point earlier, will signal to future Donald Trumps that they will ultimately lose, because there'll be new precedent on the books once again, that efforts not to turn over your tax returns to the House Ways and Means Committee is going to be met with complete disrespect by the Supreme Court. So you better do it. In other words, we don't want another Donald Trump. Whether it's it won't be Donald Trump again, but we don't want DeSantis to think that he can get away with what Donald Trump got away with, and even push the envelope, as you said, sink lower in the mud and try something else crazy. And I think now the Supreme Court is signaling, if you look at their body of law, you have to come away with the result, the synthesis of the body of law is that you got to turn over your records to whoever has legitimate jurisdictional powers in that particular area. Jan 6 to do its investigation, House Ways and Means Committee to talk about tax returns in the Internal Revenue Service, and prosecutors, if they're prosecuting a case of financial crime, turn them over, because your Supreme Court's not going to be your ultimate savior at all. They're going to tell you to turn them over.
No doubt about it. Popok, and then turning to this Fifth Circuit Court of Appeals, right-wing reputation, but they gave a bit of a smackdown to this Trump MAGA judge. It was a very harsh ruling, but appropriately so. The federal judge in question is Terry Doughty, Judge Doughty, appointed by Trump for the Western District of Louisiana. This was one of those cases that were kind of these weird AstroTurf cases brought by Republican attorney generals who have nothing better to do, like Missouri and Louisiana. The same thing, like these are the states that sued to block the student debt cancellation program, where here their big focus is not on like, well, how do we help with education and healthcare and like issues that people care about? And like, how do we focus on workers and raising the wage, raising a minimum wage to not just a living wage, but a wage with dignity? And how do we like do things for people? That's not what they focused on. They focused on, well, social media companies are moderating anti-vax conduct, and they're telling people to wear masks, and they're telling people that getting
this is a bad thing. This is a bad thing.
So the Republican states and attorney generals were like, how dare these social media companies try to, block content that spreads conspiracies about vaccines and has death threats to Dr. Fauci. We must investigate the social media companies. So they filed a lawsuit, like a batshit crazy lawsuit against the Biden administration.
Like, we can't even tell this story without cracking up that two states of our union would file a case, presumably on First Amendment grounds, pretextually on First Amendment grounds, to allow social media to spread lies and disinformation that could lead to people dying. They're in favor. Come to Missouri, come to Louisiana. We're in favor of people dying.
And this isn't even the lawsuit against the social media company, but that somehow the Biden administration, because they've said we don't like disinformation to spread on social media, that the Biden administration is now the overlords of social media, and they are suppressing the speech of hateful conspiracy theorists. And as you said, Popok, these states, their highest legal officers, their attorney generals, filed lawsuits against the Biden administration, and they got in front of this batshit crazy judge. The case is so frivolous, though, that what the states did too is they immediately sought depositions of all of these like top level people in the Biden administration. So they sought Surgeon General Murthy. They sought the head of the Cybersecurity and Infrastructure Security Agency, Jen Easterly. They saw the head of digital strategy at the White House, Rob Flaherty, Jen Psaki. This ruling doesn't relate to Psaki. They later sought Psaki's deposition.
Although it will eventually.
It will. And then the Department of Justice was like, we haven't even filed our motion to dismiss yet to the frivolous lawsuit. So can we file first off, these people shouldn't be deposed. They're high level apex officers, meaning they're top level officials. And the law says if they're a top level official, they shouldn't be deposed if there's less intrusive means.
At least not first. Maybe later.
You have to climb the ladder,
right.
which is what the law is. And we haven't even filed our motion to dismiss yet, because we did originally, then they filed an amended complaint, and this lawsuit just batshit crazy. And then the federal judge, the Trump appointed judge, is like, no, I am ordering that these people show up for deposition. They better show up immediately. So the Department of Justice went to the Fifth Circuit and went to them and were like, look at what this judge is doing. Like this stuff's crazy. Like, can you stop this judge from doing it? And then the Fifth Circuit basically said, yeah, what are you doing, Judge Doughty? Like, this makes literally no sense. Popok.
Yeah, so here's we like to give a little decoder ring to our listeners and followers about what to look for. And the good thing that happened, just as the three-judge panel that Judge Pryor put together at the 11th Circuit included two Trump appointees in the Mar-a-Lago case, but that had already ruled against Trump. In the Fifth Circuit, in terms of cherry, like you're at the jackpot, you're at the jackpot in Las Vegas. We got three judges. Two were George W. Bush appointees, meaning they're reasonable Republican appointees, and one was Obama. So we had, unlike normally when you get a couple of Trumpers in there, we had Bush from the halcyon days of the Republican Party when they weren't, as you like to say, batshit crazy. You got people who are in their 60s and 70s who are reasonable, and you have an Obama appointee. That was the panel. And so that was good because as you said, this Louisiana trial judge that they're supervising is a Trump appointee of the first order, and skipped all protocol and procedure and decided that just on the filing of a complaint, we're going to go immediately to depositions of the highest level officials of a federal government that we can find. In fact, he questioned in his own opinion, the trial judge did, whether these were really high-ranking officials within the Biden administration. The head of cybersecurity and infrastructure about the election process, as you called out, the director of digital strategy, the chief person in charge of media, social media for the Biden administration, and the Surgeon General. There was even question in this judge's mind that these people were high ranking. The appellate court was like, okay, first of all, they're high ranking. Okay, so we don't even know where you were going with that.
And they go, these people oversee tens of thousands of employees and have budgets of billions of dollars. Okay,
it's the very definition of high ranking. I don't know what you think high ranking is, Judge, but these people are high ranking, and you needed to find a least intrusive method of discovery. But more importantly, for our purposes, Ben, is another invitation from an appellate court to do something. It says in the order that we've read, I think it's a 5-page order, that upon the filing of a timely motion to dismiss by the Biden administration, the trial judge should consider whether there should be discovery going on during the pendency of that motion at all. Wink, wink. Department of Justice, file your motion to dismiss because you'll find a receptive audience at the Fifth Circuit for stopping discovery completely. Meaning what you said, Ben, is that they see this as a borderline frivolous case, if not totally frivolous case. And we're certainly not going to let, the frivolity of the case overwhelm the system and allow us to go, let's go right to discovery. Why don't we take the deposition of Joe Biden? Let's do that right away. Do that right up front in a case. No, they're going to have to get through a motion to dismiss process. It looks like the Fifth Circuit is going to ultimately rule that discovery should be stayed in the case overall while we even figure out whether there is a case here or as you like to say, a legal theory in search of a case. Is there one? Probably not, based on the Fifth Circuit, at least this panel. And let's not bother Biden administration officials with depositions on a fishing expedition, political fishing expedition by two states who have nothing better to do, but that to make sure that QAnon theories stay on the internet. What a laudable goal by a state. Why don't you worry if you're in Missouri? Shout out to Missouri, Louisiana, but negative one. Why don't you worry about birth rates and death of children, mortality rates for children in your state, education rates, testing scores, illiteracy rates, poverty rates. Why don't you worry about that instead of wasting energy, time, and money and resources on these ridiculous political trumped up cases?
I couldn't agree with you more, but that's why we do the show, Popok. The law is so important, and what we saw in the 2020 election is that what actually held everything together certainly was not the Republican legislative branch, because they were willing and still want to do a coup right now. It wasn't the executive branch because Trump was leading a coup. It was the judiciary which held everything together. There's no other way around it. And so when we call out the Judge Eileen Cannons, the Dowdies, that federal judge in Texas who blocked Biden's cancellation, Pittman. Yeah, Judge Pittman. When you start looking at these Trump appointed judges, and by the way, there have been Trump appointed judges, though, who have followed the law, and there have been some that have gone deep down into conspiracy land and eroding confidence in our judicial system. But it's why we do this show. It's why this civic engagement that we provide here at Legal AF. And when I say engagement, I mean this is a community effort. You know, we're all in this together. This isn't just like a network. This is a true community, and it's so great spending these weekends with you to discuss the importance of our legal system. I want to tell everybody here to also consider checking out our Patreon website by going to patreon.com/MeidasTouch, patreon.com/MeidasTouch. We are not funded by any outside investors at all. We rely 100% on you and your generosity. And so we're 100% independent, 100% accountable to you. There's lots of exclusive content you can only get on Patreon, but most importantly, you can help grow our independent media platform. So go to Patreon, patreon.com/MeidasTouch. Also, check out store.MeidasTouch.com, store.MeidasTouch.com for the best unapologetically pro-democracy MeidasTouch and Legal AF gear. We've got those great long sleeve shirts from Legal AF, the Wheels of Justice shirts. Check it out at store.MeidasTouch.com. I'm Ben Meiselas, joined by Michael Popok. Happy Thanksgiving to all. I am very, very thankful to you all. We'll see you next time on Legal AF. Shout out to the Meidas Mighty.